Guys, my name is Natalia Porsche and I am an immigration attorney. Welcome to my YouTube channel. If it's your first time, my name is Natalia Porsche. I'm an immigration attorney, and on this channel I discuss the latest immigration law update, what's going on in the immigration world now, what's going to happen with immigration reform. So if you like this video, subscribe to my channel, put thumbs up and leave a comment. So what's going on now with immigration reform? Well, what happened was now we have a major setback. Democrats try to propose Plan A to make immigration reform as a part of reconciliation bill. However, Senator parliamentarian McDonough rejected this. Democrats try to propose Plan B to parliamentarian McDonough. She rejected Plan B again. So now Democrats saying that they're working really hard on Plan C, but it doesn't look like immigration reform will be part of reconciliation package. So they did not present it yet. Their Plan C, they did not present it yet to parliamentarian McDonough. However, they say that they are working really hard on that. So let's see what's going to happen and whether Democrats are going to make this immigration reform as a part of reconciliation bill. There are a lot of people here in the United States which have been brought here as children. They're staying here, they're working, they're studying, they're looking for some kind of relief. To remind you, immigration reform was originally proposed by Democrats to legalize millions and millions of people who came here as children, who are working on a farm, or who came to this country because they cannot leave, they cannot stay in their own countries because it's impossible because of the national disaster. Democrats are saying that they're still researching other options to make this immigration reform as a part of the reconciliation package. Major update that we have on immigration law is new requirements for vaccination. So anybody who is coming to this country now on immigrant visa or some non-immigrants visa, guys, you have to have new vaccinations done. There are new requirements which are posted on this website, USCIS website. You can go to this website. There is also a different form, okay, that you need to review. It's the form related to medical exam. It's a new form. You can look at it, and if there is a certain time limit, if you submitted this form too early or too late, you will have to do another form, and you have to comply with Department of Health, the US Department of Health requirements, and also you will have to get your COVID-19 shots. You'll have to have your vaccine done, which is approved by the United States Department of Health. Okay, so the question becomes, so what's going to happen if, for example, you have different kind of vaccine which is not approved by the United States Department of Health? So that's where the fun part come in. So what's going to happen then? What they're going to do in order to help you guys too, if you already received the visa or you're waiting for your visa and you're going through medical examination. Like, for example, if you go through medical examination abroad, okay, so you will have to get your shots done during medical examination. You have to have your vaccination done, and this vaccination must be approved by the United States Department of Health. For more information, go to this website, USCIS website, to find out more information related to recent medical exam form as well as COVID-19 requirement for vaccines. We have also a recent immigration litigation update. So United States Citizenship Service got sued over H-4 and L-2 employment authorization document policies. So what the policy from USCIS states is that it requires an L-2 spouse to apply for an employment authorization document for employment, as well as it prohibits an H-4 and L-2 spouse from receiving an automatic extension of their employment authorization document while a renewal application is pending. Okay, in my opinion, this is well done. I think the American Immigration Lawyers Association, they did a good job with this, because I mean, what the person's supposed to do when they're waiting, when they're in this country legally, they're working, they have a work visa, they're here with their spouse and they're here with their children, they're here legally. and they have employment authorization document, okay, as well as their spouse. So they have to reapply certain amount every certain amount of time. They have to reapply. So what happens during this reapplication time? Because this reapplication time can take can take up to 6 months, maybe even longer in some cases. So they're here, they're employed with the United States employer, and United States employer is required, they're required for them to have employment authorization document in order to work for them. So what they're supposed to do. So that's the reason why the American Immigration Lawyers Association, they brought this lawsuit against USCIS, suing them for against that they don't like this policy. They want this policy to be changed. Complaint which was brought by the American Immigration Lawyers Association against USCIS was that it alleged the USCIS policy and processing delay have forced tens of thousands of non-immigrants, age holders of H-4 visa and L-2 spouses out of employment by creating gaps in their employment authorization, because they have to renew the employment authorization document so that they can stay out of work, because the employer is required to have that copy of the employment authorization form that they're legally working here, they are authorized to legally work here in the United States. So the lawsuit also alleges that the peer regulation L2 spouses are authorized to work incident to status and should not be required to apply for a separate employment authorization document for the employment. Okay, so under current policy, an H4 and L2 EAD holder must apply for an EAD to work and must cease working when the EAD expires, even if the EAD renewal application is timely filed. So I see where they're coming from, because, for example, if someone is applying for immigration benefit here in the United States, and they file the application with USCIS and that application is pending, that person is here legally in the United States because application was not adjudicated yet, right? It was not administratively adjudicated. So here they argue that the policy of the USCIS requiring them to apply before it expires is not right. So it has to be changed, that they have to be authorized to work before, if, for example, they have their EAD document is expiring. So if they apply for another EAD document by filing an extension, they have to be automatically authorized here to stay and work in the United States. That's what the lawsuit is about. Interested in this litigation, if it's something that you would like to argue also, you have to follow this. The case is called Schregel versus Maycross, and there is a case number I cited down below. And this is all I had for you. This is all immigration news. If you have any comments, leave it down below. If you like this video, subscribe to my channel, leave a comment, put thumbs up. Thanks for watching.